So hello guys, now we are trying to cover all these provisions of fundamental rights in an order inside out, so that examiner don't have any question beyond this to ask in UPSC CSC prelims 2025. So now fundamental rights. So basically what are rights? So if we talk about rights are claims of citizens. Okay, so they are claims of citizen. First of all, we should get to know this, that rights are claims of citizen. This is important because it depicts bar of all against all, against all. Okay, basically to limit us, laws were made to limit us, laws were made. Okay, now this limited freedom is liberty. Limited freedom is given to us, so limited freedom is liberty. What is liberty? To develop oneself fully. One may wonder, why do we need rights? So we need rights because for our human existence, rights are necessary. Okay. As for living, we are required food, water. So as well as to live, we human require rights also, because certain, if we don't have any rights, so state can crush us. State can have a 100% vigilance on us. There will be no liberty to us, and a jungle raj can be established. Okay, so now fundamental rights first time taken from USA. So this is a prelims fact. First time taken from USA. Enforceable against state. Okay, enforceable against state. Negative connotations to states. Okay, part 3 constitution of India. Part 3 of constitution of India, from article 12 to 35. Okay guys, so this should be remembered. This was asked in prelims, this was also asked in prelims. Okay, so article 12, basically article 12 is nothing to do with rights. It only defines like word state, like what state is. State basically can be collectively. For this time you can like government of India, understand, like government of India, government of state, parliament, है ना, parliament, legislation of state, local authorities, panchayati raj, etc. Okay guys, now Montague, one thing to be remembered. If you want, you can remember this, but it is very important as well, because what I will teach here, it whole the thing is necessary to be remembered to get good marks in prelims, and nothing can be asked beyond this according to me. So here Montesquieu, a thinker, so he basically provided us with trias politica. Remember guys, trias politica. So basically trias politica means three organs of state. Three organs of state. Three organs of state. Okay, so what is three organs of state? So these are basically executive, to keep a check on the laws, proper law implementation is carried out or not, proper law implementation is carried out or not. And one is judiciary and one is legislative legislature to make laws. Okay. And in many cases you will get to know that delegation, certain rules called delegated rules are prepared by executive also. Executive, sorry guys, it is executive also. Now, but for the time being you should only get to know that executive has a role to keep a check on the laws and for its various implementation. And judiciary, so judiciary has two roles. Now guys, listen carefully, this can be asked, and this is very important fact what I am telling you. While judicial role is addressed by Supreme Court or by any court, so judiciary will not act as state. Guys, please listen this. Not act as state. Not act as state. This is very important, guys. Please listen this. And while performing non-judicial administration, and it is considered to be as state, and this thing can be asked in prelims also. So guys, please remember this. Judiciary, while performing judicial role, will not act as state, because you know na ki fundamental rights are negative connotations to state. I have previously told you. So if they are negative connotation against state, and judiciary itself is against state in for the welfare of people, for the welfare of residents, to any person, right, anything. So if it will act as state while judicial role, performing judicial role, so it will be of no matter. And that is why a case was held, and this comes us to a new topic called, guys, please listen carefully. Now this thing is very much, maybe no one before told. नरेश श्रीधर नरेश श्रीधर मिराजकर and others versus state of Maharashtra. Now guys, this case should be remembered. This is very much important. State of Maharashtra. Guys, please be very careful and be very attentive. This video will not be too long, so that everyone can learn it very carefully. So basically this judgment, Supreme Court held that when a court is acting in a judicial capacity, right, when court is acting in its judicial capacity, it cannot be regarded as a state. What I previously told you, right? While court is acting in its judicial capacity, that is while delivering justice. While delivering justice, court cannot be regarded as a state, because fundamental rights and every rights what are given to a citizen or a person residing in India, in territory of India, and is facing anything against him, so he can directly come and take the help of our courts, judiciary. Okay, so it cannot be regarded as a state. However, when administrative actions is amendable to the jurisdiction, So basically now guys we are only studying about fundamental rights, so jurisdiction will be covered later in article 32 itself. Okay, so now we are shifting our focus to article 13. Only this much is required in article 12 what I previously told you. Okay, only this is important in context of article 12. Now in article 13, any order, any legislation, okay, any order, any legislation, any legislation amendable, amendment which violates, abridges and contravene. Guys, please repeat it before me. Violates, abridge and contravene. Any action, any order, any legislation, amendment to Constitution of India which violates, abridges and contravene. Guys, three things: violates, abridges and contravene. Anything in part 3 of Constitution of India. So basically guys, I will denote Constitution of India like this. Okay, so Constitution of India is not law. Clearly it is defined that it is not law. So basically only this is written in article 13, right? But now here we have, it is called as doctrine of judicial review. Now guys, here one thing I need to explain you. Guys, be attentive, please be attentive, so that you can get maximum advantage of this. Okay, and can reproduce in paper as well. So guys, basically when I talk about doctrine of judicial review, it is not mentioned expressly in Constitution of India. First of all, repeat before me, it is not mentioned expressly in Constitution of India. So basically from where its existence came from. So its existence came from a Marbury versus Madison case. Okay, it was not of our country, it was from USA. Okay, so it was of USA. So although judicial review not mentioned in USA constitution, but it is responsibility of judiciary that doctrine of judicial review must be followed. Guys, this is very important thing what I told you recently. Recite before me, speak before me, so that you can get maximum advantage. Okay, although judicial review not mentioned in USA constitution, but it is responsibility of judiciary. Okay guys, so please remember this. This can be asked guys, this can be literally asked in prelims, and to reproduce this you should be very attentive and listen to me. And I am also writing here, so that you can also stop the video and write and can prepare notes, because beyond this nothing can be asked in prelims according to me, because nothing will be left before this. I will tell you everything. So now fundamental rights are started from article 14. So rights of equality, now we will only discuss this rights of equality. 14, 15, article 16, article 17, article 18, article 19. Rights of equality, these must be remembered to to you. Okay, 14, 15, 16, 17, 18, 19. Or else or you can consider right of equality here also article 19, or else you can shift this to right of freedom also, because these are six right of freedom. You can tell, you can yeah, article 19 can be considered here also a right of freedom, article 19, right? And afterwards, rights of protection. So here is article 20, 21, 22. Guys, I will literally do in very much detail these rights. Okay guys, and nothing will be left beyond this. What I will teach, nothing will be left after this. According to me, I will not left anything to you if you are watching these videos. Okay guys, next, right against exploitation. So these are only article 23, 24. Okay guys, you can note it down. I'm literally writing this much. Now shifting to the next page. Okay guys. Rights of religious freedom. Article 25, 26, 27, 28. Guys, please speak before me. A right of religious freedom, article 25, 26, 27, 28. Because this is very important to be remembered. These are the facts which are generally can be asked in prelims and are asked in prelims. Guys, please be attentive. Be attentive. I'm telling you, be attentive. Okay. Okay. Next, we have cultural rights. Cultural rights are covered in Article 29. Next, compulsory acquisition of property. Article 31. Yeah, okay. And next is rights of constitutional remedies. Constitutional remedies. Constitutional remedies. Article 32. And lastly, exceptions to these fundamental rights. Article 33, 34, 35. Okay guys, so please remember this is very much important. Now, right of equality, article 14. So I will cover article 14 in very great detail, so please be attentive guys. Now I am damn sure if you will watch my videos peacefully and prepare notes of it, है ना, that's why I'm writing this. So that you can stop the video and can write as well, or with the video, with the flow, you can write and remember everything will be remembered by you. I will cover in detail and in very detail, so that nothing will be left. Guys, please be attentive. Now article 14. So article 14 basically is state shall not deny to any person equality before law. Okay guys, please recite if before me. State shall not deny to any person equality before law or equal protection of laws within territory of India. Guys, please remember this. Now here it is. Now guys, please listen to me. Equality before law or equal protection of laws. So basically these are two concepts which we will understand in further video. Okay, so equality before law, what it means that every person is equal before law. Every person is equal before law. Every person is equal before law. Equality before law, sorry guys, equality before law is every person is equal before law. Like guys, when you visit Supreme Court, so you will see a photo of of a lady whose eyes are covered, right? आंखों पे पट्टी बंधी होती है ना? तो वही चीज़ मैं कह रहा हूँ कि इक्वलिटी बिफोर लॉ, लाइक दे विल ट्रीट एवरीवन एज इक्वल, एवरीवन विल बी ट्रीटेड इक्वल. It is negative concept, it is negative concept, guys, please listen very carefully. It is negative concept, it is negative concept. Equality before law, negative concept, guys, please report before me. I'm telling you, very important. Equality before law is negative concept. This reproduces what we call don't discriminate in the eyes of law, in the eyes of law. And these things are very important and are covered under English common laws, right? Guys, this is very important, this can be asked in prelims, so it is very very important. So please be attentive, guys. The equality before law is negative concept. It is like everyone will be treated equally in the eyes of law. No discrimination in the eyes of law means if I commit a crime, or a or a child commit a crime, so no discrimination in the eyes of law. What punishment I get of committing pre-planned crime, or what crime a child committed without knowing, in unintentionally, so both getting equal representation in the eyes of law, both will get equal in the eyes of law. Okay, so both will get equal punishment, both will get equal punishment. Likewise, I will give an example on this, like, guys, like, yeah, I am telling you, like, if now I will shift to Hindi, so that one can understand in a very effective way, because our thought processing language is Hindi only, right? सो हेयर इट इज़ लाइक, मेरे पास एक गन है और वो मेरे ही पास है, ठीक है? अब अगर मान लो कि मैं उस गन को लेके और किसी से एक प्री प्लान्ड मर्डर परफॉर्म कर देता हूँ, ठीक है? मैं प्री प्लान करके किसी को गोली मार देता हूँ, तो जितनी सज़ा मुझे मिलेगी उतनी सज़ा, अगर बाई चांस मेरे पास गन है और वो मेरा बच्चा आता है और वो बहुत छोटा है, लाइक वो 3 साल का है, तो वो आता है और वो अनइंटेंशनली उस गन को निकालता है और किसी पर चला देता है और वो बंदा मर जाता है, तो उसको भी उतनी सज़ा मिलेगी. एंड दीज आर द इंग्लिश कॉमन लॉज. सो दिस इज नेगेटिव कंसेप्ट. ओके है. एंड सेकेंड इज इक्वल प्रोटेक्शन ऑफ लॉज. Equal protection of laws. So in equal protection of laws, reasonable classification. Guys, this word is very important, please. This is very important word, please be attentive. Reasonable classification. What reasonable classification means, like separate treatment in the eyes of law. Okay, separate treatment in the eyes of law. Okay, guys, in the eyes of law. So here it is. So separate treatment in the eyes of law, this is positive concept. Okay, positive concept. Special treatment on the basis of regional classification. Special treatment on basis of regional classification. Reasonable classification. Reasonable classification. Reasonable classification. Reasonable classification, right? So now, guys, be attentive here. I told you positive concept. What it is? Equal protection of laws. Equal protection of laws is a positive concept. Okay, so what is it? So guys, मैं फिर से एक एग्जांपल देता हूँ. Please guys, be attentive and be alert. So positive concept, what is it and how can it be explained to you guys in a very easy way? So in a very easy way, what I previously took as example, like, it is my gun, मेरे पास गन है, and I am pre-planning a murder, and I am performing it, right. So I will be treated in a different way in the eyes of law. In the eyes of law, I will be treated as a different way. I will be treated as in a different way, in accordance with, if my gun is took by my child and he unintentionally fires on it on somebody else and he is dead, and if he is end up and the person is dead. So in the eyes of law, I, because I have pre-planned a murder, I will be considered differently, basically in a different way. In the means, I will be come in CRPC article 3 and 302, attempt to murder. If of course, guys, if he is alive, and if he is dead, so so to be hanged by neck till death, right? CRPC 302 will be considered to me. But on the other hand, if my child committed a crime, if my child unintentionally took my gun and shoot somebody unintentionally without planning a murder, so maybe the court, maybe judge can leave it, and the matter is ended upon, and nothing will be held, and no charges will be framed against my child. Okay, no charges will be framed against my child. Okay, so this is it. And and here we complete article 14. Equal must be treated as equal, guys. Now here also, what it is, reasonable classification. Reasonable. So always reasonable classification is there. reasonable classification का मतलब ये नहीं होता है, कि मेरे पास ज़्यादा पैसे हैं और मैंने कोई मर्डर करा तो मेरे पास ज़्यादा पैसे हैं तो मुझे कम सज़ा मिलेगी, और किसी और ने कोई प्री प्लान मर्डर करा, वो गरीब था तो उसे कम सज़ा मिलेगी. दिस इज़ नॉट कॉल्ड रीजनेबल क्लासिफिकेशन. रीजनेबल क्लासिफिकेशन कैसे होना चाहिए? इन द आइज़ ऑफ जज, इन द आइज़ ऑफ कोर्ट. कोर्ट डिसाइड करेगा. कोर्ट के हाथ में है, हर चीज़ कोर्ट के हाथ में है. इक्वल मस्ट बी ट्रीटेड इक्वल, अनइक्वल मस्ट नॉट बी ट्रीटेड इक्वली. So here we, based on intelligible differentia, guys, please recite before me. These words are very important. Based on intelligible differentia, right? So equal must be treated equal. Here it is, guys. Equal must be treated equal, and unequal must not be treated equal. Equally. Okay, guys, based on intelligible differentia, guys, please remember this word. This is very important. What I'm telling you, based on intelligible differentia, relied upon the eyes of judge. Okay, guys, this is performed by intelligible differentia. Intelligible differentia is what? According to the mindset of the judge, in the eyes of judge. Okay, guys, in the eyes of judge. A law that requires all people of above the 18 to vote is valid. Guys, please listen carefully. I am telling you example. Please listen it very carefully. A law that requires all people over the age of 18 to vote is valid because it is based on reasonable and rational discrimination. Age is what? Rational distinction, reasonable distinction. So these are the works what you should catch. It has a legitimate purpose. If I am telling about intelligible differentia in the eyes of judge, so what is it? It is not a illegitimate purpose. It is not for a illegitimate purpose. It is for a legitimate purpose, guys. Legitimate purpose must be is followed. Legitimate purpose must be followed. Okay, it is like, likewise I am telling you most of the examples I already told you. According to me, you guys have understood these topics, like age is a purpose, which can be like, likewise a crime committed, but it is intentionally, but in an intentional way or unintentionally. So guys, it has nothing doing with illegitimate purpose. Illegitimate purpose will not be covered here, guys. Please be attentive. Illegitimate purpose is what? So illegitimate purpose is that if somebody ऑफर्स मी मनी, व्हाट वी कॉल इन हिंदी इज घूस देना, है ना। सो अगर हमें कोई घूस दे दे कि हमने मर्डर करा है, प्री प्लान्ड है, तो तुम इसको सजा दे दो, हमें कम मिलेगी क्योंकि वी आर रिच, है ना। सो दिस क्लासिफिकेशन सो दिस क्लासिफिकेशन इज नॉट डन, इज नॉट ट्रू। इंटेलिजिबल डिफरेंशियल must follow legitimate purpose. Okay, and here some and here some exceptions are there. Okay guys, exceptions are everywhere. So it's like SCST Act of 1989, JJ Act 2015, Juvenile Justice Act 2015. Okay, Juvenile Justice Act 2015. And diplomatic immunity is always provided. Diplomatic immunity is always provided. Persona non grata deals with according to your bylaws. So guys, I am telling you a new term, like diplomatic immunity. Diplomatic immunity is what we called in a maxim called persona non grata. Persona non grata. Okay, so it is what deal with him according to your laws. So guys, this is it. And I can also I can also tell you example on this, like diplomatic immunity. If you are selected in UPSC films and you chosen to be a IFS and you are posted somewhere in a country, in a diplomatic area, so if you committed a crime there, so you won't get punished according to their laws. According to their laws, you will be immediately departed in our country, because you are officer of our country, so you will be dealt according to our Indian laws. You won't be dealt according to their laws, because diplomatic immunity is always provided. Okay guys, and secondly, on the floor of house you are not answerable to court of law. So these are exception. On the floor of house, it is like in parliament, है ना, in parliament, state parliament or state legislature or parliament, like Lok Sabha, Raj Sabha, everything on the floor of house, you are not answerable to court of law. You are not answerable to court of law. And also exception of article 361 is here, what I am remembering. For official functioning, president, governor not accountable to criminal offense, guys. ठीक है, to criminal offense. In civil proceedings, a notice must be given. A notice must be served. Okay, guys, a notice must be served. So here it is. लाइक इसका एग्जांपल है ना, जैसे देते हैं, जैसे इसका एग्जांपल हम ऐसे देख सकते हैं कि मानो प्रेसिडेंट और गवर्नर है, तो मानो अगर कोई नेशनल इमरजेंसी लगी, या कोई इंटरनेशनल, या कोई ड्यू टू इंटरनेशनल फाइट्स, कोई भी इमरजेंसी लगती है। अब उसमें प्रेसिडेंट ने, मानो प्रेसिडेंट एज वी ऑल नो सुप्रीम कमांडेंट ऑफ आवर फोर्सेस, ठीक है। तो अगर प्रेसिडेंट ने ऑर्डर करा कि हाँ भाई यहाँ पे हम फोर्सेस को डिप्लॉय करते हैं, और वहाँ पे मानो कोई भी ट्रेजिडी हो गई, मानो कोई मर गया या किसी का घर टूट गया, तो हम ऐसा नहीं बोल सकते कि हम प्रेसिडेंट के खिलाफ कोर्ट ऑफ लॉ में जाएंगे और प्रेसिडेंट वो जो घर टूटा है उसका पैसा देगा। तो ये नहीं होता है गाइस, ये कभी भी नहीं होता है, क्योंकि आर्टिकल 61 यही बोलता है। एंड दिस इज द एक्सेप्शन इन आर्टिकल 14 व्हाट यू शुड बी नोन। ओके, सो नाउ वी विल शिफ्ट टू आर्टिकल 15। नाउ आर्टिकल 15, Article 15 is state shall not discriminate against any citizen. Guys, please spoke before me. It is very important. State shall not discriminate against any citizen on ground only of race, religion, caste, sex, place of birth, or any of them. So guys, this is it. Likewise, it is written that state shall not discriminate against any citizen on the ground of what? Guys, please be attentive। और ये वाले जो ये 5 हैं, इनको आप प्लीज़ बोलिए। रेस, रिलीजन, आप कौन सी रेस के हैं, लाइक यू आर ब्लैक और वाइट और एनीथिंग एल्स। रिलीजन, नथिंग मैटर, यू आर हिंदू, मुस्लिम, सिख, पारसी, anything. Caste, what caste you belong. Sex, like you are male, female, or anything. LGBTQ, belonging, or place of birth, or any of them, ठीक है। Okay, so here it is, and it is the beauty of our Indian constitution। Okay, in what manner it is written, what a great thought of Baba Sahib, we shall be proud of him। Okay, he proclaim some lines what I want to show you. Like he said, we are imposing equality on a society which is inherently unequal। Okay guys, so this is very huge statement if we will consider। Likewise, you know कि in modern India what our condition was, and from ancient India also what our condition was। Like we always discriminate, like ये बहुत छोटा है, ये बहुत गरीब है, ऐसे वैसे करके। तो हमने कितना सोसाइटी में कितना हमने अनइक्वलिटी प्रीच करा था। तो ये चीज़ ख़त्म करना, मतलब ये चीज़ लिखना, ये अपने आप में एक बहुत हिम्मत वाली बात है कि बाबा साहेब इज़ अ सॉलिड मैन। बाबा साहेब मतलब जितनी तारीफ़ करो उतनी कम है। मतलब उसने क्या सोचा, मतलब व्हाट अ ब्यूटी है। आई एम तो अमेज्ड कि वी आर इम्पोजिंग इक्वलिटी ऑन अ सोसाइटी विच इज़ इनहेरेंटली अनइक्वल। मतलब ही नोज दैट वी आर अनइक्वल, and he's writing down that we are inherently unequal, but now state shall not state, it is a negative connotation against state, that he state you shouldn't discriminate on the to any citizen, to any citizen। Guys, this is also important, please see this, citizen on the ground of, guys please recite the ground before me: race, religion, caste, sex, place of birth। And here you should remember 15 sub clause 3। Only remembrance can make you feel very easy You can make a special provision for women and children. So guys, this is it. Equality helps us on need basis. So we have equality, we have equality, but we in true sense we don't have equality, or it is not called equality. It is on help as on need basis. As what is needed, it will be provided by state, so that everyone can be on a equal bench. If everyone is on equal bench, likewise I'm remembering the example. Yeah, okay, no problem. So equality is helps as on need basis. In order to achieve equality, what must be provided by the state? What must be provided by the state? It's called to achieve level playing field. Okay guys, so that everyone can start in an equal way, must be achieved. Level playing field must be achieved. Okay guys, level playing field must be achieved. It is called affirmative action. Okay guys, it is called affirmative action. Affirmative action in spirit of article 15. Yeah, okay guys. So here it is. Like you already know that in recent past in modern India, how women condition deteriorated, how women and children were treated. They were very discarded person. They were discarded from everything because of their formation, and they were engaged in multiple things. They were sold out as well, in previous examples of modern India, है ना? So they left behind. So when we were doing everything, we were trying to achieve everything, so they were very left behind. So they were left behind. That's why they should be provided help as on their need basis, so that they also come on the same playing level field, and we can start from a common point. If we will start from a common point, then one must achieve what he does. Okay, so here it is. And PYQ, you must remember at last. PYQ, must remember PYQ. Equality is absence of privilege. It is very important guys, please listen this very carefully. Now, equality is absence of privileges. If privileges are absent, so this is equality. Now, in 1950, guys, please remember this year, because in recent past multiple MCQs were asked that 4 to 5 cases of Supreme Court judgments were given, and we have to arrange that in a chronological manner. So while arranging in that chronological manner, we should also remember the year that in what Supreme Court hearings were carried forward. Okay, so in 1950, Srimati Champakam Dorai Rajan, Champakam Dorai Rajan approached to the courts, ठीक है, against state of Madras for medical seat. For medical seat, because government of India in 1927 said that some seats are reserved. So case became Champakam Dorai Rajan versus state of Madras, 1951. Guys, please remember the year 1951. Champakam Dorai Rajan versus state of Madras. Okay guys. So now I'll tell you, guys, please be careful. This is very important thing, or else you will miss everything. So basically it is basically violation of आर्टिकल 15 एंड आर्टिकल 29. सो गैस पहले तो आपको ना मैंने एक बार कंटेक्स्ट बता देता हूँ जिससे यू विल फील इजी इन अंडरस्टैंडिंग एवरीथिंग. सो इट इज़ व्हाट कि चंपकम दो राजन वर्सेस स्टेट ऑफ मद्रास में ऐसा हुआ था ना कि चंपाकम दो की उसकी एक सीट थी, तो वो मेडिकल सीट थी, तो वो उसने उस पर एक्वायर करने की कोशिश करी कि मुझे सीट मिल जाए, लेकिन उसको वो सीट मिली नहीं बिकॉज GOI एक्ट 1927 में उसको रिजर्व्ड कर दिया गया था, बोला गया था कि ये सीट रिजर्व्ड है. सो देन सो आफ्टर वर्ड्स नो बिफोर like one thing guys, listen, like first 1927 came, then our country became independent. Then 1950 came. Okay, so when we became independent, so then we became independent after 1950 came. So fundamental rights were written down. Our constitution was written. Fundamental rights were written down. So when fundamental rights were written down, so it was, so before it was not clear that these things must be ended upon. So this model was continuing from 1927 till 1951, but when it came in the eyes of laws, in the eyes of justice, so this happened. So basically this is, so according to Champakam Dorai Rajan, she was saying that it is violation of article 15 and 29 if the seat is not given to her. Okay, like article 15, I previously covered what is it, in article 15, and in article 46 it is DPSP, guys. So in DPSP, state shall promote with special care. It is state shall promote with special care, special care, education and economical interest of SC, ST and other weaker section of society, and other weaker section of society. Okay, guys. So it is basically conflict between part 3 and part 4 of the constitution, right? So here we come. So so I already told you that it is a conflict between part 3 and part 4 of the constitution. Whenever there shall be a conflict between part 3 and any other part of the constitution, part 3 will prevail. You already know this. I told you before that whenever there will be a conflict, so I will, guys, I can write it down also if you can't remember this. Whenever there shall be a conflict between part 3 fundamental rights and part 4 DPSP of constitution, part 3 will prevail. Okay, guys, part 3 will prevail. First CA 1951 amended it. You have to know this. First CA 1951 first constitutional amendment act 1951. I am not writing this, but you can write this. First constitutional amendment act 1951, 15 subclause 4. Nothing in this article added है ना, nothing in this article shall prevent the state from making any special provision for advancement of any social and educationally backward classes. citizen or for SC ST. So basically, what is it? Ki 15 subclause 4 allows reservation. Okay, guys. For whom? For whom? 15 subclause 4 provide allows us for reservation for social and educated backward classes of citizen or for SC ST. Likewise for women and for SC ST. ठीक है? Okay, guys. So here it is, and you should remember this can be asked. This is a very well known fact, and this can be asked in prelims as well, and nothing can be done. You must have to remember, and you should recite before me. 15 subclause 5 93rd CA 2005. 15 subclause 6 103rd CA 2019. And these are, and what these are called, 15 subclause 4, 15 subclause 5, what these are called, protective discrimination. So guys, for fundamental right, you should only know this much, and for Chamkam Dorairajan case, you should only know this much, because after this I have to move inside the topic of governance, but I am limited to only, I am stuck to only fundamental rights only. So for this is very pure remembrance. Like 15 subclause 5, it came from 93rd CA 2005. 15 subclause 6, it came from 103 CA 2019. 15 subclause 4 and 15 subclause 5 are what called as protective discrimination. Right, guys. And now we come to Article 17. Article 17 is abolition of untouchability. And its practice in any form. Is forbidden. Okay, guys. And for this, a delegated law is also acts behind, like state, SC, High Court, Supreme Court, individual punishable in accordance with law. I previously told you that act also works behind this. Article 17, punishable in accordance with law. Parliamentary law also. Constitutional provision have statutory backing. Protection of like what laws? Protection of civil rights Act 1955. Okay, guys. 1955. Okay, guys. SC/ST Prevention Act of 1918. Untouchability. So what is untouchability? It is called as jurisprudence of inverted comma. Guys, please remember this. This is very important. Jurisprudence of inverted comma. Okay, guys. So now we will shift towards what? Article 18. Article 18 is those state title which are dynastic and not merit based academic. So which are dynastic and not merit based. And now merit based is what somebody become doctor, so doctor title will be available before him, or somebody become engineer, so engineer will be called, or any of a person like Sachin Tendulkar, he has taken a prize है ना, so he will be, so that is covered under this, like what academic titles are covered. Academic title like doctor, engineer, or any other title which is provided by state itself for a field in which a person excelled, for a field in which a person excelled. So there, so basically merit based is allowed, merit based is allowed, ठीक है. लेकिन it everything merit based, everything is allowed, like you can military title allowed, gallantry titles allowed, national awards allowed, to recognize the excellence in performance of duties. Okay, court at max can ask government to withdraw these titles. Court at max, what can court can then, to court at max can ask government to withdraw these titles, but titles which are dynastic are not allowed. So basically what, abolition of dynastic based title, abolition of titles which are what, dynastic based, ठीक है. So this is article 18 covered. Now guys, this is end of it. Article 14, 15, 16, 17, 18, 9, 17, 18, everything is covered. And now we have to move on, right of freedom. So guys, article 16 is missed accordingly. Article 16 missed. Article 16 is equality of opportunity in matter of public employment. Equality of opportunity in matter of public employment. In matter of public employment, there shall be equality of opportunity of all citizens in the matter of relating to employment to office under state. What it covers: race, religion. Guys, please recite before me: race, religion, sex, caste, place of worship, descent, residence. Okay guys, so this is it. And now guys, if you watch this video completely, you will get to know about article 14, 15, 16, 17, 18, 19. अब कोई रिवीजन करते हैं गाइस, और उसके बाद फिर इस टॉपिक को यहीं पे ख़त्म करते हैं, ठीक है. तो राइट ऑफ इक्वलिटी, आर्टिकल 14 में क्या बोलता है कि इक्वलिटी बिफोर लॉ and equal protection of laws. Equality before law is negative concept. It is what, don't discriminate in the eyes of laws. It is English common laws. It emerges from English common law. And equal protection of laws, it is reasonable classification allowed. पॉजिटिव कंसेप्ट स्पेशल ट्रीटमेंट देने की बात करता है, रीजनेबल क्लासिफिकेशन की बात करता है. एंड इक्वल मस्ट बी ट्रीटेड इक्वल, अनइक्वल मस्ट नॉट बी ट्रीटेड इक्वली. इसके बाद फिर उसकी कुछ एक्सेप्शंस हैं. एक्सेप्शंस मैंने बता दिया कि क्लास लेजिस्लेशन अलाउड है, क्लास लेजिस्लेशन नहीं अलाउड है. मैंने बोला क्लास लेजिस्लेशन नहीं अलाउड है, डिप्लोमेटिक इम्यूनिटी अलाउड होती है. आर्टिकल 661 के हिसाब से प्रेसिडेंट गवर्नर को क्रिमिनल ऑफेंस में नहीं कैन बी नॉट बी सूड इन द कोर्ट. सिविल प्रोसीडिंग्स, अ नोटिस मस्ट बी गिवन. आर्टिकल 15 बोलता है कि स्टेट शैल नॉट डिस्क्रिमिनेट to any citizen, race, religion, caste, sex, place of birth or any of them. इक्वलिटी बोलते हैं कि एज ऑन नीड बेसिस बोलते हैं. उसके बाद फिर मैंने चंपकम दो राजन वाला केस बता दिया, उससे वो इमर्ज हो गया. उसके बाद फिर आर्टिकल 16 होता है. आर्टिकल 16 में फिर बोलता है कि इक्वलिटी ऑफ अपॉर्चुनिटी इन द मैटर ऑफ पब्लिक एम्प्लॉयमेंट. देयर शैल बी इक्वलिटी ऑफ अपॉर्चुनिटी फॉर ऑल सिटीजन इन मैटर रिलेटिंग टू एम्प्लॉयमेंट टू ऑफिस अंडर स्टेट. सो इट इज़ रेस, रिलीजन, कैस्ट, सेक्स, place of birth, descent, residence. So five of previous article: race, religion, caste, sex, place of birth, and descent and residence added. Okay, here. And then article 17 tells us about abolition of untouchability and practice in any form is formidable. ओके गाइस, उसके बाद फिर इसको बोलते हैं जूरिस्प्रूडेंस ऑफ इन्वर्टेड कॉमा. ये पेपर में आया वो क्वेश्चन. आर्टिकल 18 होता है, वो बोलता है कि डायनेस्टिक टाइटल नहीं अलाउड है, लेकिन वैसे वाले जो टाइटल होते हैं वो अलाउड होते हैं, जिसमें गैलेंट्री अवार्ड आ जाता है या फिर मिलिट्री टाइटल अलाउड होते हैं, एवरीथिंग इज अलाउड, कोर्ट एट मैक्स कैन आस्क गवर्नमेंट टू विथड्रॉ दिस टाइटल्स। उसके बाद गाइस अब हम नेक्स्ट पार्ट अगले नेक्स्ट वीडियो में करेंगे। और इफ़ यू लाइक दिस वीडियो, इफ़ यू वॉच दिस वीडियो एंड यू फाइंड एनीथिंग जो आपको लगता है कि हाँ समझ में आया या कुछ भी है, या फिर कोई भी डाउट होता है, तो आप मुझे अपना कमेंट सेक्शन में पूछ सकते हैं। और इसके बाद we will meet in next video, signing off from this video. Thank you. If you like this, press the bell icon, keep support me guys, likes करिए, it will be very helpful. Thank you, बस यही मांग रहा हूँ और कुछ भी नहीं। and guys please study as well, and this is it. Thank you guys.